Good morning. You have everything you need? All right. Michelle, do we have Commissioner Keene online? And is Commissioner Keene online or no? All right. This is Chair French, joined by Commissioner Keither here this morning, and I am convening the hearing on the unanimous settlement agreement in the matter of Black Hills Kansas Gas Utility Company LLC, DBA Black Hills Energy, for approval of the commission to make certain changes in its rates for natural gas service, KCC docket number 25 BHCG 298 RTS. Quick announcement, you'll see Commissioner Keene is not here this morning. I understand he was a bit under the weather. He may join us on Zoom, but he also may not be here. So, all right, if you are participating online, please do bear with us if you experience any technical difficulties. I am going to begin with the entries of appearance, please, starting with Black Hills Energy.
Good morning. James G. Flaherty, Ottawa, Kansas. Douglas Law, Omaha, Nebraska, and Jeff Danjo, Fayetteville, Arkansas, on behalf of the applicant, Black Hills Energy.
All right, thank you. Good morning. Seaboard Energy.
Good morning, commissioners and council. Jim Sikora and Molly Morgan on behalf of Seaboard Energy. Thank you.
Good morning. For Kansas Municipal Gas Agency, KMGA.
Good morning, Terry Pemberton on behalf of Kansas Municipal Gas Agency.
Good morning, Terry. Citizens Utility Ratepayer Board, CURB.
Good morning. May it please the commission, Joseph H. Drab, Consumer Counsel on behalf of the Citizens Utility Ratepayer Board.
All right, thank you. Good morning. And finally, for KCC staff.
Good morning, Commission. Patrick Hurley and Phoenix Anschutz appear on behalf of KCC staff.
All right, good morning. Just before we move on, are any other parties on Zoom that wish to enter an appearance? It's my understanding we have everybody we're expecting. All right, hearing no one else, let's.
Mr. Chairman, Luke Silva here on behalf of Freedom Pipeline.
All right, thank you. In the room. Good morning. We will now move on to notice of this hearing. Does staff have a recommendation regarding notice of the hearing?
Yes, Mr. Chairman, staff has examined the notice and reports that an initial procedural scheduling order was filed by the commission in this docket and served on the parties on February 19th, 2025. Which set today's date as one of 3 dates for an evidentiary hearing. On June 17th, 2025, the commission held a pre-hearing conference and issued an order which was served on the parties, shortening that time frame to a 1-day hearing on this date and changed the start time from 9 a.m. to 10 a.m. The parties have conferred and engaged in communication relating to a hearing procedure for today's date. For these reasons, staff recommends the commission find notice was proper under Kansas law.
All right. Are there any objections to notice of the hearing?
No objection.
All right. Hearing no objections, I will find that notice is proper and the commission has jurisdiction to hear this proceeding at this time and place. I want to move on to preliminary matters. First, I understand the parties would like to move to admit all the pre-filed testimony into the record. Mr. Flaherty, do you intend to present that motion?
Yes, I can. So the parties have agreed to submit all of the pre-filed testimony and exhibits, including the application and the minimum filing requirements, into the record. They've agreed to waive cross-examination. So at this time, I'd ask that the pre-filed testimony and exhibits that have been filed in this case be referred into the record.
All right. Are there any objections to that motion? Hearing none, the motion is granted. All the pre-filed testimony is admitted into the record, and we will note that the parties are all waiving cross-examination today. Are there any other preliminary matters the parties wish to address before we move on to the procedure for the hearing? Hearing none, we are going to move to the procedure, and I understand that Black Hills Energy has requested to make an opening statement of approximately 15 minutes. After opening statements will follow the order of witnesses that was agreed to in the pre-hearing conference. And I also understand that in that pre-hearing conference, the parties did waive the closing statements. So that will be our procedure for today's hearing. Mr. Flaherty, if you wish, you may begin with your opening statement.
Yes, thank you. And you should have copies of the PowerPoint presentation I intend to use so you can follow along on the opening statement. And Michelle, if you could put that up on the overhead, that'd be great. All right, so we're here this morning to present to you the unanimous settlement agreement for your review and approval. And that's the purpose of today's hearing. Before I get into the terms of the settlement, just wanted to give you and the YouTube audience some general information about Black Hills Energy. Did we? There you go. Thanks. So up on the screen is a map showing the service territories that Black Hills Energy serves basically through the middle of the United States. They provide both natural gas and electric utility service in 8 states in those service territories. And the map shows those states in which they provide that service. Michelle? Oh, there you go. So this slide shows the service territories that Black Hills serves in Kansas. It serves approximately 120,000 Kansas customers, natural gas service. Those service territories include Lawrence, the Wichita and Hutchinson area, Southwest Kansas area, including the cities of Garden City, Dodge City, and Liberal, and the Goodland area. So in this case, Black Hills Energy filed its rate case in February of 2025. Once that case was filed, there were a number of interventions. The parties listed in this case are set forth on the overhead. The settlement conference that was scheduled by the commission was held on June 5th of 2025. All of those parties that you see on the screen participated in that settlement conference. And one thing I would point out to the commission, and we'll get into a bit later on in this opening statement, is how you go about reviewing the settlement agreement. Includes the factor relating to whether or not the settlements in the public interest. And one thing I would point out is that the number of parties that intervened and participated in the settlement conference provided a really good cross-section of all the various different types of customers that Black Hills serves in Kansas. For example, you know, your staff represents the public generally. CURB represents the residential and small commercial customers. We had 2 marketing companies, Wood River and Symmetry, who provide transportation service to mainly commercial and industrial customers. And we also had 3 large transport customers that, again, provide a very good cross-section or representation of the types of customers that we serve. KMGA has a number of members that take transport service from Black Hills. Seaboard is a large industrial customer that takes service from Black Hills. And then Freedom Pipeline, which is made up of irrigation customers and agricultural businesses that also takes service from Black Hills. So out of those, you had a good representation or cross-section of all the types of customers that Black Hills provides service to. The settlement that we're presenting to you today was agreed to by all the parties. It addresses all the outstanding issues that were raised in the pre-filed testimony. That pre-filed testimony has been submitted into the record this morning and can be relied upon and should be relied upon by the commission in looking at and reviewing and approving the settlement that's been presented to you today. In addition to that testimony, basically staff, Black Hills and Curb have filed testimony in support of the settlement. Chad Unrein, who's the Chief of Accounting and Financial Analysis, is filing testimony on behalf of staff. Audrey Benham, who's a regulatory analyst with Curb, has filed testimony in support of the settlement on behalf of Curb. And Robert Daniel, who's the Director of Regulatory for Arkansas and Kansas, is submitting testimony and will be here to answer any questions you have in support of the settlement today. So there are 13 primary issues that are addressed in the settlement. I plan to walk you through those during this opening statement. Some of them you're going to be very familiar with and are included in most of the settlements that are filed in these natural gas utility rate cases. For example, it's pretty typical to have a stipulated revenue requirement deficiency with the rebasing of the GSRS revenues that are already being collected from the Kansas customers. Another one that you've seen in most of these rate case settlements is the pre-tax rate of return, in most cases to be used in the GSRS, as it is in this case, but also because the parties have agreed to an abbreviated rate case, that pre-tax rate of return will also be used in that proceeding as well. You're also going to see on these on this list of issues, maybe issues that you're not that familiar with or aren't in other rate case settlements that you've seen previously. Just to give you a couple of those as examples, the abbreviated rate case is one that you may have seen in one or two rate cases before. And when we come to that issue, I'll give you more description of that. Another one is right below that, the deferred accounting insurance tracker. The parties have agreed to implement a tracker following the insurance expenses of the company. And again, I'll get into some more detail about that tracker and how it's going to work when we discuss that specific issue. So this other slide, again, addresses or sets forth the terms of the settlement. Again, most of those are pretty much familiar with. I would point out that the parties did agree as part of the global settlement to request that the commission have an effective date of new rates for August 1st, knowing that the order is not due until August 29th. But again, as part of the global settlement, the parties did agree to, because of the hearing today and the fact that the commission is going to have 30 days after this to meet that August 1st date, parties agreed to request that from the commission. So let me get into the first issue, which is the stipulated increase to the revenue requirement. The overall annual revenue increase is $15.2 million. As in other gas utility rate cases, that overall annual revenue increase is going to include revenues that the company's already being recovered under the GSRS surcharge. In this case, it's $4.4 million. So when you take that out of the $15.2 million, you reset the GSRS to zero, then the new net annual revenue increase, in this case that was settled by the parties, is $10.8 million. This slide shows basically a comparison of where the parties' positions were with respect to the new net revenue increase and what was agreed to by the parties in the settlement agreement. As you can see, what was stipulated to by the parties is at $10.8 million. That compares to Black Hills' annual new net revenue increase that was set forth in their rebuttal testimony. And there's reference there where you can find that in the pre-filed testimony that's been referred into the record of $13.9 million. Staff recommended a net revenue increase of $9.2 million, and CURB recommended a new net revenue increase of $13.7 million. So as you can see, based on that comparison, that the stipulated revenue requirement falls within the low end staff's $9.2 million and the high end Black Hills Energy's $3.9 million of the various recommendations. And I would point out that in coming to that dollar amount, that was based upon all the recommendations made by the parties. In this case, there were 29 expert witnesses covering accounting, economics, engineering. All those witnesses had extensive experience and expertise. The parties all had expertise in following how this commission has reviewed similar issues in other rate cases. And all the parties had a couple goals in mind, basically to avoid the cost of litigation and to see if, based upon all those recommendations that again are in the record, can be reviewed by the commission, could they come up with an amount that they could all agree to, and that's the $10.8 million that's included in the settlement. With respect to issue 2, the pre-tax rate of return, again, the parties each had, in the parties, I say staff, CURB, and Black Hills, all had experts that provided their expert opinions on what the capital structure, return on debt, and return on equity should be used to set rates in this case. There's a difference of opinion with respect to each of those issues. But the 8.37% pre-tax carrying charge that's included in the settlement and is necessary to include in the settlement because you need that number to determine the calculation of future GSRS filings. And as I mentioned earlier, also to be used in the abbreviated rate case filing that have been agreed to by the parties. But that 8.3% is based upon, if you took, for example, the capital structure proposed by the 3 parties, the return on equity, the cost of debt, and I think Mr. Unrein does a pretty good job in his testimony in support of the settlement, basically looking at all those various opinions and positions on those 3 issues and how you could look at each of the positions and come up with the 8.37% pre-tax rate of return. So even though there wasn't agreement on the capital structure, the return on equity or cost of debt, it's not correct to indicate that that's not based upon substantial competent evidence, because it is, and it's based upon the expert testimony that was presented in the pre-filed testimony that's been referred into the record. So the parties are agreeing to that carrying charge. It's solely for the purpose of the GSRS and the abbreviated rate case. And if tax rates change, that pre-tax carrying charge will change as well. So if, for example, if there's federal tax rate changes because of what's going on in the federal government, then that will be reflected in a change to the carrying charge if that occurs between now and the next rate case. Okay, so you'll notice in the settlement that the parties included a provision that they agreed not to agree on the capital structure, the rate of return, and the cost of debt. And again, that's basically to allow the parties in the next rate case to continue to take the various positions that they have on those issues. The next issue is the abbreviated rate case. So the parties agreed on an abbreviated rate case under the commission's rules and regulations that allow for the abbreviated rate case to be filed within 12 months after the order in this rate case comes out. It's basically, the abbreviated rate case is very limited in scope. It is to capture basically the CWIP or construction work in progress after February 28th, 2025. And the parties also agreed that it would capture plant in service to be updated through December 31st, 2025, including the other attendant impacts on depreciation, deferred income taxes and things like that. So in order to set where that abbreviated rate case is going to start, it'll be after February 28th, 2025. It will run through December 31st, 2025. It's limited to the plant and service. And in order to establish that amount, the parties agreed to what that adjusted rate base was as of February 28th, 2025. And that number is included in the settlement. Another item that you may not see in other natural gas rate cases is this deferred accounting insurance tracker. And so basically if you see in the pre-filed testimony, there were significant increases in Black Hills' cost of insurance. Now you can probably, just looking at the news, probably understand why you see these utility companies having increases in their insurance costs because of wildfires, other extreme situations that they face. So with that in mind, the parties agreed to come up with insurance tracker similar to the type of tracker you would see currently with pension and OPEB costs. And typically the commission has approved these types of trackers when two things occur. One, there's a significant variance in the cost or expenses. And number two, that those costs or expenses are outside the control of the utility. So in this case, what the parties agreed to is allow for this insurance tracker to track both increases, and if for some reason between now and the next rate case, those insurance costs were to go down, to track those as well. Those will be reported just like the pension and OPEB in the next rate case. The parties did agree to staff's recommendation that we would sunset this in the next rate case. And hopefully by then, these insurance expenses have settled down. And also, the parties agreed to staff's recommendation that it's going to require Black Hills to support that cost recovery of the deferred balance in its next general rate case filing. And then finally, just as you see in the pension and OPEB expense trackers, the parties have to agree in the settlement, as they did in this case, to the amount of insurance expenses that are embedded in base rates. So the tracker will basically track the difference between that number that's embedded in base rates and their actual expenses, and basically set up an accounting order to recover or pass back to customers in its next rate case. Something that you are familiar with in these settlements relating to gas utilities are certain accounting matters that the parties have to agree to in the settlement in order to track certain items for accounting purposes. This basically identifies those, and those are very familiar to what you see in other rate case settlements. So for example, the ad valorem tax surcharge, there's an embedded amount set in the base rates. And then each year, if that expense goes up or down, then that's tracked through the ad valorem surcharge, which is allowed by legislation. With respect to amortization periods and expenses, Black Hills, the parties agreed that Black Hills could recover its actual rate case expense. It's going to be amortized over 5 years. That tracks basically Black Hills' record recently of basically filing a rate case every 5 years. As I mentioned, the pension and OPEB expenses that are being tracked, those are going to be amortized over 3 years and basically trued up in the next rate case. Those amounts have to be set, and as well as the amounts that also are in the base rates. Issue number 7, again, you're probably familiar with this tax adjustment rider, probably seen it recently, and other utility rate cases and settlements, relating to the various tax changes, both at the federal and state level. In this case, the parties agreed on the proposal that Black Hills has that amount that's listed there, 2.95 million, that is going to be refunded to customers through the tax adjustment rider. The hope is to refund that over this upcoming winter to perhaps offset somewhat, at least at a minimum, the rate increase if this settlement's approved by the commission. Issue number 8, again, something that you're familiar with on class cost of service and rate design, which is basically, okay, now that we've agreed upon the revenue increase, how do we allocate that revenue increase among the various customer classes? And for example, how do we determine, once we do that, how much of the increase is going to be recovered under the customer charge? And those things, again, the parties, while they weren't able to come to an agreement on which class cost of service methodology they were going to use, or they were able to reach agreement on the allocation of the rate increase among the customer classes. That's set forth on attachment A to the settlement. They were also able to agree, obviously, on the rates that allocation presents. That's also on attachment A. And let me just point out the one thing that was significant to curb, as it has been in other cases, and that's the residential and commercial customer charges. The parties agreed with setting the residential class customer charge at $21 per month. That's consistent with the commission staff's recommendation, and the commercial customer charge at $32 per month. We would like to continue our position on trying to get more of our fixed cost recovered through the customer charge. And so the parties have agreed that all the parties reserve their rights to make the positions that they did in this case in future rate cases. With respect to weather normalization, this may be of some interest to the commission. There's typically this dispute as to how do we determine normal weather? Do we use the last 10 years, or we do, in some cases, I know the commission looks at a 30-year period. In this case, the parties agreed to use a 10-year period to determine normal weather, and based upon that, then came up with the basically the coefficients that are going to be used in the W&A rider, and that's set forth in attachment B to the settlement. So the interveners in this case were very interested in several of the revisions that Black Hills was proposing to their transportation tariff in this case. And then also KMGA had an interest in separating out the class that they're in into different subclasses to determine whether or not the cost would change for that particular class. So you'll notice that with the transportation tariff revisions in the settlement, some of the tariff revisions the parties were able to come to an agreement on, and those are set forth in this slide, the next slide. But there were also tariff provisions that the parties were not able to come to an agreement. And instead of holding up this case or litigating those specific issues that the parties could not come to an agreement, it was proposed and agreed to by all the parties that we would set those aside. We would into a separate docket and have those issues teed up in that separate docket. That separate docket's supposed to be filed pursuant to the settlement after a final order is issued in the abbreviated rate case. We're hoping that will give all the parties time to get together and try to work out the various differences on those issues. These issues were important to Black Hills coming out of Storm Uri and those other events that have occurred in trying to come up with ways in which to fairly protect the sales customers. Obviously, the interveners in this case had significant issues relating to those, and all the parties at the end of the day decided it was worthwhile to set those aside and try to tackle those in a separate docket. So in probably about a year or so, you'll probably see that docket being filed, and hopefully again, the type of cooperation that existed in this case, we can come up with some solutions for those issues that were raised. The other transportation tariff revisions, again, had to do with the aggregation enrollment. We came to an agreement on that. We also came to an agreement on the non-telemeter daily balancing service charge and the changes in the gas quality specifications and the LVI telemetry requirements. With respect to KMGA's concern, Black Hills agreed that in its next general rate case, it would include as an alternative a class cost of service study that would break out or separate out the LVS customer class into subclasses: firm, transportation, interruptible customers. While we're not obligated in any way to advocate for those alternative class cost of service studies, we have agreed to provide those, and I'm sure you'll see that issue in the next rate case. Issue number 11, there were other tariff revisions that the company had proposed. One related to access to customer-specific information. Black Hills has now changed that provision in its tariff so it mirrors more like Evergy and Kansas Gas Service, to where customer-specific information is on is going to be protected from being released to third parties. Kerr made a couple of recommendations on that. The parties, as part of this global settlement, agreed to those recommendations. With respect to issue number 12, I've already discussed this. And again, as part of the global settlement, the parties agreed to request from the commission that the rates coming out of this case become effective on or before August 1st, 2025. And then finally, you'll notice the typical miscellaneous provisions that are included in all the settlements, protections both on the commission side as well as the party side that, for example, in the event you decide that you don't approve one of the provisions and that provision was material to one of the parties, then the parties have the right, any of the parties have the right to no longer go along with the settlement. Finally, let me get down to how you're supposed to, or what your job or duty is today in looking at, okay, do we approve this settlement? So this commission has set up 3 factors when there's a unanimous settlement as to how they go about determining whether or not a settlement should be approved. Those factors are set forth there. All 3 witnesses that are going to be testifying this morning address each of those factors. So, and I think I've addressed a few of those in my earlier comments, but you're familiar with those, and that gives you a good roadmap. So as long as all the evidence in the record, including the pre-filed testimony that was entered into the record this morning, provides what the courts, I guess, have called a zone of reasonableness, that there's something in the record that supports how the parties agreed on certain items, then that meets that factor. Just and reasonable rates, again, that zone of reasonableness is your roadmap for that. And if it's in the public interest, and I mentioned early on the public interest in this particular case, like I said, we had a very good cross-section representation of all the types of witnesses. I'm sorry, all the types of customers that Black Hills serves. So, and we were able to reach agreement on all of those different types of customers. And so that should give you a good indication that this is in the public interest. So in conclusion, the recommendation to the commission is that the parties would ask that the commission issue an order approving the unanimous settlement, and to the extent your schedule allows you to issue an order so that the new rates can go into effect on August 1st, 2025. That's been requested by the parties. Thank you.
All right, thank you, Mr. Flaherty. I understand no other parties requested an opening statement. So Mr. Flaherty's statement will reflect the description of the settlement agreement. At this time, we will move to examination of witnesses. And Michelle, if you could take down the screen share so I can see the Zoom, just in case our colleague Commissioner Keen joins us, I could hopefully see that. And he has not joined, correct? Commissioner Keen? Okay. You might just flag me down if you do see him pop up. With that, so we will move to examination of witnesses, and Black Hills, you may call your witness.
Thank you, Your Honor. Black Hills would call Robert Daniel.
And if you'll please stand and raise your right hand. All right, Mr. Flaherty, go ahead.
Thank you. And Mr. Daniel, if you can pull that up closer to you. Can you please state your name and business address for the record?
Yes, my name is Robert Daniel. My business address is 655 East Millsap Road, Fayetteville, Arkansas, 72703.
Mr. Daniel, who are you employed by?
I'm employed by Black Hills Service Company, representing Black Hills Energy in this docket.
And what is your position?
My position is Director of Regulatory with responsibilities for Arkansas and Kansas.
And have you been authorized to testify on behalf of Black Hill Energy in support of the settlement?
Yes, I have.
Your Honor, since the testimony has already been referred into the record, I would tender Mr. Daniel for questions from the commission.
All right, thank you. Yes, since all the parties have waived cross-examination, we will just move to commissioner questions. Commissioner Keither, do you have any questions for this witness? No questions. All right. I've got a few for you, Mr. Daniel. Good morning.
Good morning.
Well, let me just cut to the chase on my first question. Then they may get a little more mechanical after this one, but it looks like in reviewing the settlement and the testimony, this is roughly on a net basis about a 9% rate increase overall. When you remove the GSRS portion, which is already being collected in rates, it looks like staff and Black Hills both calculated it out, used a little different assumptions for what a normal residential customer is, but for a typical residential customer, it looks like about a 9% increase. So that's definitely a material rate increase on someone's bill, or a bill increase. What are customers getting for that that they weren't getting before that increase? What does that buy them?
Thank you for the question. First off, I'd just like to note that Black Hills Energy, since acquiring the Aquila system, and I forget what year exactly that was, but mid 2000s, we've had 3 general rate case dockets here before the commission: 2014, 2021, and the instant docket. In the 2014 case, the company, or the commission, approved approximately around an $800,000 new revenue increase. In the 2021 case, the settlement that the commission approved was a $0 new revenue increase. And obviously this case, the settlement before the commission is a new revenue increase of 10.8 million. So to look backwards, what that tells me is that we, as a Black Hills, Kansas entity, have ran our business very well in terms of controlling cost throughout the last, over a decade. So what are customers getting? Hopefully they've gotten the benefit of the lack of general rate increases over the last 12 years as a result of this. Inflationary factors were a very large reason of why we're in for a case now. We've seen that rise in the last few years, which has put cost pressures on both expenses and capital projects. We've seen the cost of debt rise as we've had to refinance debt throughout the company. Customers will continue to receive quality service, safe and reliable service, and investments that support the entire customer base throughout the state.
So just as a follow-up on that, since you laid it out so clearly, that there's really only been an $800,000 annual increase in 2014 and really no increase since then. And then all of a sudden, sort of a 10.8 annual increase. And you did lay out that that's inflationary factors, upward pressure on capital project costs, cost of debt has increased. Is that really all it is? Is there acceleration of capital investment as well along with that? Or is it really just sort of the baked in costs have gone up?
To answer very simply, it really is just the baked in costs have gone up.
Okay.
Company has not accelerated our Kansas capital investments and done our absolute best to manage expenses throughout this time to the benefit of customers. And that's what we plan to continue to do. With rising cost of capital projects, ultimately what you get is less for your dollar. So spending more with potential longer regulatory lag sometimes just doesn't make sense for anybody, customer, shareholder, company. So we have to be very careful with how we spend our capital dollars and what we use that on, given these high cost and high inflation environments.
So I noticed one of the primary drivers you noted was increasing operational expenses since 2021, and your rate case then, or your test year then. You've had your test year now. Have you been able to see any trends in operating expenses since this test year for this rate case?
It's a good question. I've not examined that since the test year for this case. I will just make a note that, from the 2014 general rate case to the 2021 general rate case, the Black Hills, Kansas business was able to keep operational and maintenance expenses virtually flat for that whole time period. That was not the case, for the last 3 to 4 years, and that's largely out of our control, given the price of everything that's gone up. And I know customers feel that in many different ways, and so do we. So, and it's really just a general overall increase in the cost of doing business.
And talk quickly about your abbreviated rate case. So that would not include any upward trends in operating expenses. That is, at least my understanding is that is associated more on incremental system investment and cost structure changes in your financial costs, correct?
That's correct. The only items that will be evaluated during the abbreviated rate case are the plant and service investments, the accumulated depreciation associated with that, the depreciation expense, and then deferred income taxes. So those 4 items are the only things that will be evaluated I believe per the statute, which I don't have in front of me, the specific statute. No cost of capital changes can be made.
That's right.
And the parties did agree, and I don't think any party proposed that expenses be evaluated in the abbreviated case. So it would be very limited. And as we Black Hills sees it more of a compliance type filing than a general rate case type filing.
Related to sort of your plan to capital spend, is it over the coming years, is it Black Hill's plan to fully utilize the GSRS each year in subsequent years?
Yes, that is absolutely the plan. And it's my understanding that the commission approves the abbreviated rate case, since that will take our plant and service investment through 12/31/25, the effective clock will start for GSRS on January 1st, 2026. And the company does plan to continue to utilize that going forward.
I think the last thing I had, your council piqued my interest. Tell me about the 10-year, the agreement on using a 10-year weather normalization adjustment, why that's reasonable from the company's standpoint. I've heard a lot of discussion of changing how we view weather normalization and, you know, the reasonableness of going back all these 30 or 40 years in today's environment. Why have you agreed to the 10-year weather normalization adjustment? And do you see that being more of a standard moving forward, or do you think it's something you'll just evaluate in every case?
Great question. The parties did agree to that for the purpose of this case. I'll note first that that was part of the settlement agreement the commission approved in the company's prior case. The simple fact is that the last 10 years have been warmer for whatever reason. Customers are using less gas on a use per customer basis. So when you think about normalizing your revenues over 30 years, which at this point may be colder, in the future it may not. But at this point may be colder, you're getting a number that says your customers are going to use X amount. In reality, they're using something much lower than that right now. So you're not matching up your customers' usage with what you are building into your rates for their usage. So in this case, a 10-year weather normalization more closely aligns with our customers' usage at this time. And we will continue to evaluate that, as I'm sure staff and Curb will as well.
Okay. And ultimately, the goal is just to get the right number, right?
Exactly. It's yes.
So that rates can accurately collect the revenue requirement that they're trying to collect.
Correct.
Yes. I don't believe I had anything else for you. Let me check my notes. Your counsel did a very good job of comprehensively describing the settlement, so I don't think I had anything else. Anything else, Commissioner Keither? No. All right, no more questions from me, Mr. Daniel. Mr. Flaherty, any need for redirect?
No redirect.
All right, well, with that, I believe we can dismiss you from the witness stand. You may step down. Thank you for your testimony. Curb, you may call your witness.
Thank you, Chair. At this time, Curb calls Audrey Benham to the stand.
Do you solemnly swear affirm the testimony you're about to give will be the truth, the whole truth?
All right, go ahead, Mr. Astrop.
Thank you very much. Please tell us your name and spell your name for the court reporter.
Audrey Benham, AudreyBenham.
Thank you. And what is your occupation and business address?
I am a regulatory accountant for the Citizens Utility Ratepayer Board. And my business address is 1500 Southwest Arrowhead Road, Topeka, Kansas, 66614.
And are you the same Audrey Benham that caused to be filed direct testimony on behalf of Curb on May 9th, 2025 and settlement testimony on June 16th, 2025 in this docket?
Yes, I am.
Okay. And do you have any changes or corrections that need to be made to the testimony that you filed in this docket today?
No, I don't.
Okay, thank you. And I know we've already omitted the testimony you referenced today, so at this time I would tender the witness for commissioner questions.
All right, thank you. Good morning, Ms. Benham.
Good morning.
Commissioner Keither, do you have any questions of this witness? I actually do not have any questions
Oh.
for you either.
Okay.
So I don't believe there will be any need for redirect, obviously. But we do thank you for your testimony. We reviewed all of it. And at this time, you may be dismissed and you may step down.
Thank you.
Thank you. All right, finally, staff, you may call your witness.
Thank you, Mr. Chairman. The staff calls Chad Unrein to the stand.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Good morning, Mr. Unrein. Please state your name, position, and place of employment for the record, please. Press it. There you go.
Okay. My name is Chad Unrein, and my position for the KCC is Chief of Accounting and Financial Analysis.
And place of employment, please.
of
Place of employment, please.
the Kansas Corporation Commission.
Okay. And are you the same Chad Unrein who filed testimony on May 9th and June 16th, 2025 in this docket?
Yes,
And do you have any corrections or updates that you want to make to that testimony in this matter?
I would say I just want to give an update. Primarily, it's on page 17. When we did our analysis of the average customer impact, we used the 50 therms that was the original number in the testimony. The updated number is 53.6. And so that kind of settles the difference in between the parties. So.
And just for clarification, Mr. Unrein, is that on May 9th testimony or June 16th testimony?
The June 16th.
Okay. Any other updates you want to give?
No.
Then I tender the witness to the commission for questions. Thank you.
All right, thank you, Mr. Hurley. Commissioner Keither, any questions for Mr. Unrein? Oh, I've got a couple for you. Mr. Unrein, if you can turn to pages, really it's 14 and 15. I just want to talk about sort of staff's position in updating its revenue requirement in advance of the settlement. So it's my understanding that you've got this this chart on page 14, and then you go in to describe it. It's my understanding that you took a look at Black Hill's rebuttal position and their responses to staff's audit, and on certain items, maybe continued to disagree, but on certain items, felt it was appropriate to update your position. Is that correct?
That's correct.
And you updated both sort of revenue requirement impacts on the income statement adjustments, revenue requirement impact for rate-based adjustments, and you made an update for changes in capital structure, right?
That's correct.
Okay. And so all three of those things together really moved staff's position from that $13.56 million number to, if you had to go to litigation or at a full hearing, it updated it to the position you would ultimately be going in at was about 15.03 million, correct?
Yes, that is.
Okay. Thank you. And just to make sure that I see this on an apples to apples basis, this is not the net number. This is the overall top line revenue requirement number, right? Or base rate revenue requirement number.
Yes.
Okay. And so that $15.03 million updated staff number could be compared to the $15.2 million number in the settlement.
Yes,
Okay, so they are very close.
they are very close. After we took a look at the rebuttal positions, we kind of went through, we would say the difference between the 15.032 versus the 15.2 would result in litigation risk and costs that would have been required to otherwise litigate the case.
I guess that was going to be my next question, is if we went to hearing and spent a few $100,000 on rate case expense, we'd be getting very close to the settlement number.
Yes,
Correct.
if not over. And that's kind of why we pursue settlements in these dockets, because essentially, if we can get to a place that we otherwise are comfortable with the parties kind of settling at, you don't go through the full litigation risk and kind of result in the public having to fund that
Yeah,
via rate case expense.
that would be built into rates as well, correct?
Yes,
Yeah.
that's correct.
The only other real thing I wanted to explore was, I guess, on your update to capital structure. And where it caught my eye was on page 19. You had one possible scenario of a settlement capital structure, and it included a 9.8% ROE, which would be just slightly higher than staff's filed position, but it also had a different capitalization ratio than staff's filed position. Instead of 45.76% equity, it upped that to 47.5. So about a 2% change in increase in equity and decrease in debt. Where is that purely hypothetical, or is that more reflective of the updated capital structure following Black Hill's rebuttal testimony?
So no, that's more of a hypothetical number, but essentially the way we got there is we looked at the parties' positions during that docket. Staff took the 45.76% number as being Black Hill's corporate number overall. And what we did is look at our individual position. I think Herb had a hypothetical at 50-50. And so we said, hey, let's look at this in between a position between us and the 50-50 that would result, and look at what type of ROE that produces and see whether we're within a reasonable range. And we believe we were, and it resulted in a 9.8 ROE. The other tables within that testimony represent staff's original capital structure, Black Hill's original capital structure, and Curb's original capital structure. And the ROE ranges in between that were 9.45 to 10.05 for those positions.
Okay, so one follow on. If I go back to staff's table on page 14 of your testimony, those revenue requirement figures or change in revenue requirement figures, those would have staff's filed position on capital structure and cost of debt and cost of equity baked into them?
Yeah.
Okay.
So yes, I mean, the change in capital structure, what we simply did was go through and look at what the 8.37 ROR would produce. And, you know, the actual kind of plugging those formulas into the overall statements, or I guess settlement schedules that we had done. And then we looked at the change kind of representing where our original position would be, and then that follow-on position.
Okay. I think that gives me enough. I don't have anything more for you, Mr. Unrein, but I do see that Commissioner Keen has joined us. Commissioner Keen, welcome. You're here just in time if you'd like to ask any questions of Mr. Unrein.
Thank you very much. Well, my apologies for not being there in person and for joining late due to circumstances, frankly, somewhat beyond my control. Actually, the line of questioning that you directed to Mr. Unrein with respect to the net revenue increase staff proposal versus the settlement agreement proposal was exactly the line of questioning I was going to direct him towards. So we need not duplicate that. Thank you. That's it for me.
All right, very good. Commissioner Keither, anything else? Okay, I don't believe there are any more questions from the commissioners. Any need for redirect from staff?
No, redirect, Mr. Chairman.
All right, thank you, Mr. Unrein, for your testimony. You may step down.
Thank you.
All right, with that, we have come to the conclusion of all three of our witnesses. Don't believe there is need for any more questioning at this time. So this does conclude our hearing in docket number 25 BHCG 298 RTS. Want to just ask at this time if there is anything more the parties need before we adjourn? No. All right, a commission order in this docket is due by August 29th, 2025. However, we do recognize that the settlement agreement is requesting the commission issue an order and approve effective rates rates effective to take effect August 1st, 2025. If there are no further matters, we will adjourn. Thank you.
Thank you.